the very top. Now you're asking, how is the CBA or this 7.9 going to affect? Obviously, a worker gets up every morning to go to work because he wants a payment. The agreement, the contract that you have signed with your employer is that you'll come to work and your employer will do what? Will pay you. And so the 7.9 has not been paid to these members from 2017. But these workers diligently have been waking up every morning since then, July 1st, 2017. He or she knows the employer has not paid me, but nonetheless, I'll wake up and go and do the work. They have done it. They have done it. And therefore, they have done this, perhaps at the expense of their own comfort. Some of them have had to borrow money to keep themselves up with legitimate expectation that at the end of the day, what my union negotiated for me will be paid to me. They're saying that. So the 7.9 is money that is owed. In fact, these members are saying, if need be, the union should be asking of the interest of this money that has accrued over the years. But we're not even going there. We're just saying, okay, fine, you pay what you owe. But the worst would have been asking both the principal and the interest that this money has earned. But allow me just to get back on what my colleague has indicated a little while ago. You see, the problem with our universities that is causing us to be where we are is lack of good faith and goodwill from the government of the day and the employers. Because there's no way we will sit with you as social partners. We engage and agree. But then you're hiding a dagger behind your back. When we have agreed and signed, we are now carrying this document together with you and place it before a court of law for registration. Then you remove your dagger. You say, my lord, I'm objecting to that particular document from being registered. That is lack of goodwill and good faith. You are the cause of the problem. But as if that is not enough, you decide now the matter becomes a suit. The matter becomes being prosecuted, which is okay because every Kenyan has a right to go to court to seek justice. Whenever you feel aggrieved, you go and do that. But when you do that, you're doing that to seek justice so that then you can be able to dispense off with it and move on. Look at what happens in the university in this particular matter. They went to court. Then the court said, okay, fine, you have raised your objection, but because we want these students to continue learning and the university is running, I, the court, am going to register this document, this agreement on the interim basis, so that the rest of the university operations, the learning and all other programs continue while I listen to you. And the court listens. You are allowed to bring your submissions and all the witnesses and everything to the court and argue. We are talking about the government. The Minister of Education, the National Treasury, the Salaries Administration Commission, and the University Council, 4 government agencies, are the ones in court opposed to what we have assigned with them. Okay? And so they bring all their argument before a court of law. And then when the court has heard the parties, the court now makes the final judgment. That is now 15th January 2021. The final judgment is made. The court says, after looking at all these submissions you've made here, we rule that the cost of this CBA is not 8.8, it is 16.57 billion. That is the salaries together with the pension liabilities. Now, that is a court judgment. You as a government agency, what are you supposed to do when the court has made a final judgment? You are supposed to obey. obey that judgment.
Right.
What do they do? Instead of going ahead and paying, because the court says, now you go, work together. The National Treasury, Minister of Education, SRC, the Salary Administration Commission, and University Council work and ensure that you get extra financial budgetary allocation to get this thing done. That is in 2021. You decide, no, I'm going to appeal against this, which is again their constitutional right. Okay, so they go to a court of appeal, file the notice of appeal, obtain a stay. Now this is where the exemplification of bad faith and bad manners. After obtaining the stay, okay, and filing a notice of appeal, you just decide now to sleep on your job. You don't want to go there now. You do not want to go further and file the record of appeal so that this matter is adjudicated and prosecuted fully. How can you call that? So that now when we as workers in the university, we keep asking, but what is happening with the arrears that we agreed with you since 2017? You show us the stay order. And then you tell us, this matter is in court. Then you keep it. Then you keep silent. From 2021, 2022, 2023, 2024. If that is not bad faith and lack of goodwill, then we don't know what it is. You don't bother. Until when the unions now decide, no, an appeal process has a specific time frame within which it should be prosecuted. Let's go back to court and now ask, this matter has been lying here for all these years. Kindly, your lordship, give us a ruling. And that was now March 2025. The court now of appeal gives a ruling. It quashes that stay, right? And that record of appeal is also rubbished. And the court says, you go back to the judgment that was delivered on 15th January 2021, pay. And in so doing, the AG, who was representing all these government agencies in all these suits, writes on 15th of April 2025, writes the parent ministry telling them, you know, we have lost our case.
Pay up.
Now, get this money and pay the staff so that we forget about this matter.
All right.
Now, when you look at that judgment, there is nowhere it says that money be paid in phases. Are you saying that?
Yes.
It's not saying that. It's saying pay.